Thank you very much. And standing on existing protocol, the place of international court under the African court as African Charter on Human and People's Rights, which is the counterpart to European Court on Human Rights and the American Court on Human Rights. So the short overview of the African Court on Human and People's Rights is similar to the American Court and the European Court. It protects the human rights in Africa and interprets the African Charter on Human and People's Rights. That is the African Court on Human and People's Rights. So it has a more expansive mandate. The court is based in Tanzania, where it holds, So the court mission is to protect, promote, and defend human rights enshrined in the African Charter on Human and People's Rights, which is the main human rights instrument on the African continent. That is the African Charter on People and Human Rights. It does so by interpreting the provisions of the Charter and by judging African states which have allegedly violated these rights. Then also NGOs and individuals can access these rights. It's not only the state, For an NGO to be able to access and submit complaint to the African court, the concerned states must have allowed them to do so. So if an individual or NGO wants to access the court, want to bring a case at the African Court of Human Rights, it has to do so through the state. Well, the interplay between the African Court and the international treaty, international court, to what extent and in what way do municipal domestic courts apply the rule of international law? Well, I've heard international law being mentioned several times in this conference, and so how far do municipal court or domestic court apply international law? It's also a tug of war here. So the conflict, between the African court and the international court, that's assuming that in the international law or international court, there is a surrogacy is being applied, to any African state, or there's a conflict between international law, international treaty, and the international law, which prevails, Obviously, the court, the Supreme Court in Nigeria has held that in the event of conflict between international law and domestic law, the domestic law prevails to the extent of the inconsistency. This is very important because international law binds upon consent. International law is not like an international Supreme Court, I studied international law in school, so I have a little bit of idea of what international law is all about. It binds upon consent. It doesn't automatically bind states. And in Nigeria practices what is called the monist doctrine, in contrast to the dualist doctrine. The monist doctrine, in contrast to the monist doctrine, Nigeria practices the dualist doctrine. Dualist system means that if an international law, international treaty is signed, it does not bind on Nigeria automatically. Nigeria and many African countries, only very few African countries that it binds automatically. It has to pass through what is called domestication. It has to be domesticated by the parliament before it is binding. Okay? Why? Because so as to suit with the Nigerian reality and cultural and philosophical conviction. The United Nations has held that any law that binds a country must conform to their cultural, religious, and philosophical conviction. United Nations. So you cannot make an international law and assume that it binds automatically on countries. It is no. The answer is no. And this is what's happened in the case of surrogacy. If you look at the African Charter, you find that there are many provisions of the African Charter that does not allow surrogacy. It doesn't mention it by name. Surrogacy is a new concept. A new phrase. Okay? But when you talk about selling of babies and trafficking in babies, in Nigeria, I said yesterday that surrogacy is banned, is also perceived as trafficking in babies, because when a woman goes and starts renting the womb, in fact, in many African countries, it's not called surrogacy, it's called renting of the womb. In Botswana and Cambodia, Ghana, it's called renting of the womb. That's what it is called. And it is completely repugnant to good conscience, you know? And this is based on natural law. At times, when we talk about these things, it's not just on culture, but something that is repugnant. So under the African Charter, surrogacy is incompatible, you know, with the provisions of the, because the African Charter talks about protection of the family, okay? And to preserve and strengthen the national independence and territorial integrity of the country, that's another way of doing that, okay? You don't just import things that are incompatible with the philosophy of the people and it binds. To preserve and strengthen the positive African cultural values. There are many positive African cultural values, you know, and that's what the African Charter is all about. So anything that is in conflict with it is not allowed, no? So international law is not an exemplar of municipal law, not an exemplar of domestic laws, no? There have been cases by the Supreme Court cases that rule that in the event of conflict between international law and domestic law prevails to the extent of the inconsistency. Why? I've explained that, you know, every law that is applied in every state should conform with the reality in that state. It makes a lot of sense. Conform with the reality in that state. You cannot be in New York or London or whatever and dictate how a law can be made in Cambodia or in Botswana, okay? So in determining what a country legal obligation and right may be, the critical factor is actual state practice. Actual state practice. There's nothing like international Supreme Court that whenever it rules, it binds every country. No. A country has to consent to it. This is very, very important. You know, I know we have the Universal Declaration of Human Rights of 1948. That's universal, okay? And if you go there, you see many things that have to do with protection of the family. In fact, that is the only legal instrument that many nations are agreed to. Universal Declaration of Human Rights of 1948. Outside that, there's none. So actual preference has to be given to policy, fundamental objective, and aspiration of that state. That's actual state practice is what really matters, okay? It's not about, contrary to the views of some jurists, refusing to accept the interpretation of international law adopted by other states, a state is not violating its international obligation. Because we're always told that you are violating your international obligation. I say, how? I mean, something you made without my consent, I wasn't there. How are you telling me that I'm not fulfilling my international obligation? What is international obligation varies from one state to the other. It's actual state practice. It is merely exercising its rights as an independent sovereign state to determine what it takes as an international law. So there's nothing like every country has a right to make laws for themselves in accordance with their respective constitutions. I told you that Nigerian practice the dualist system, whereby any international law that is signed by state ministers, they come back to Nigeria, the parliament will have to assess what they have signed in the light of Nigerian reality. If there's any conflict, it is thrown out. What I have been doing over the years in Nigeria is to guide the parliamentarians to make sure that they do not pass as law that are in conflict with our cultural heritage. That's what I've been doing. And whenever we bring it up, they say, "Oh, that is correct. That is correct. We're not going to sign it." So that president goes and signs a law is not automatically, it's not automatically applied. The locus classicus here is the case of Abacha versus Fahimi. It's a local law in Nigeria. And the Supreme Court unanimously concurred that an international treaty entered into by the government of Nigeria does not bind, does not have a binding force until it is made law by the National Assembly. That's Nigerian practice. So I mentioned the international law binds upon consent, and if you want a foreign case, international law binds up. The case of Madbury versus Madison, Justice Marshall said that there's nothing like international Supreme Court that decide how each sovereign state ought to interpret or apply a given international norm. The interpretation of one sovereign state is not better or worse than interpretation of another sovereign state. Okay, in their paper, their juries have always said that, look, there's nothing like supreme international court that binds every nation. I think during questions and answers, I will expatiate on that. Let me stop here so far. But the summary is that international law has to work, binds to the extent of actual state practice, and it does not automatically bind, as in the case of Nigeria, it applies the dualist system, whereby if the president or the ministers have signed a treaty, that treaty has to be domesticated by virtue of Section 12 of the Constitution. And to the extent that surrogacy is in conflict with many provisions of the African Charter on Human Rights, it's completely that conflict has to be resolved in favor of the African Charter on Human and People's Rights. Thank you.